Good afternoon. Maybe I should say good evening, depending where you are. Distinguished colleagues and guests. It is my pleasure and honor to welcome you all. Today is the final day and the final session, and welcome you all the final day and final session of the highly topical and important conference. I would like to introduce myself before starting. My name is Sarkan Kaya, and I am an assistant professor at Boğaziçi University Faculty of Law, and I will be moderating this session. As a moderator, I will be monitoring the time. I am now delighted to hand over the floor to distinguished speakers. So I would like to introduce Mrs. Fatma Nur Cebeci Çorum. She's a PhD candidate at Swansea University. She will be speaking to us on can AI be an inventor and international analysis in the light of Davos decisions. Floor is yours, Mrs.
Can you hear me right now? Sorry.
Yeah, we can hear you.
Okay. First of all, I want to thank you for this organization and for this opportunity. I am Fatma Nur. I am a PhD researcher in Swansea University, and today I will be talking about can artificial intelligence be an inventor and international analysis in light of Davos decision. Starting with what is Davos actually? Davos is an artificial intelligence system which is created by Mr. Teller. And Mr. Teller claimed that food container and devices and methods for attracting enhanced attention has been created independently by Davos. And he said Davos was not created to solve any particular problem and was not trained on any special data relevant to these present inventions. He said it is trained with technical documents and knowledge, so it's able to generate inventions on its own. After these claims, he applied for a patent protection in 18 different jurisdictions. My aim is today just to briefly explain what happened so far in the different applications and what's the current situation right now. Starting with the United Kingdom Intellectual Property Office, the UK IPO has received an application from Mr. Teller, and in this application, inventor has been claimed as Davos, and applicant was Mr. Teller. Mr. Teller said, "I am the applicant because I own Davos." And Section 7 of Patents Act 1977 actually regulates inventor as an actual deviser of the invention. Because of that definition, Stephen Teller claimed that in the UK patent law domain, there is no such requirement that there is a need for human inventor. Everyone or everything who actual deviser of the invention could be regarded as an inventor. However, the UK IPO did not satisfy with that argument, and they said the applications shall be withdrawn since Davos cannot be regarded as an inventor, and Mr. Teller is not entitled to apply for a patent simply by virtue of ownership, as the derivation of the right to apply for a patent has not been sufficiently provided. Mr. Teller appealed this decision, and High Court was also agreed on with the outcome of the UK IPOs, and Mr. Teller has also appealed High Court's decision. And the latest decision we have seen in the UK was the England and the Wales Court of Appeal decision, which was in September 2021. In this decision, the judges said, "We have reviewed the case law. We have looked for the history of the UK patent law, and we have interpreted a number of provisions of the Patents Act, and they said inventor had to be a person within the meaning of the Patents Act. Secondly, they said machines had no rights, including the right to apply for a patent. Therefore, Mr. Teller cannot have any rights by being the machine's owner. As a result of these two justifications, this appeal was dismissed by the majority. After that decision, Mr. Teller has applied for a special leave to appeal that decision. And we heard that in August 2022, permission to appeal has been granted. Which means that in the UK, we will be seeing at least one more decision regarding those cases. What happened in the European Patent Office and EPO? Actually, the very same application has been made by Mr. Teller to the European Patent Office. They said, we are the inventor. The inventor is the Dabus, but I am the applicant. The difference was here is Mr. Teller firstly said, I have a right to apply for a patent because I am the employer of Dabus. But after that explanation, he filed a correction form and he said, I have a right to apply for a patent because I am the successor in title as the machine's owner. I am the assignee of IP rights, which is created by this machine. The patent applications also refused by EPO because they said naming the machine as the inventor is not compatible with European Patent Convention, and they said AI systems does not have any legal personality. Therefore, they could be a part of employment agreements. Therefore, they could not be a part of any employment agreement, and they did not have any legal rights or titles that can be transferred to anyone. Teller appealed this decision, but Board of Appeal was also agreed with the European Patent Office outcome. They said in the Board of Appeal, definition of the inventor in the Oxford English Dictionary is required a human. Because there's a need for a human inventor, we cannot accept AI system as an inventor. Furthermore, they said derivation and transfer of the rights just simply being ownership of Dabus does not comply with Article 8.1. Therefore, there is no valid transfer. However, Stephen Teller has also applied a divisional patent application in the European Patent Office, and this divisional application is still pending, which means that in the EPO, the case has not closed yet. What happened in the United States? Actually, the scenario was the same. The applications has been rejected by the USPTO because there is a lacked a valid inventor, and since inventors on a patent application must be natural persons, Teller appealed this decision again, and Court of Appeal decided that there was no ambiguity that inventors should be natural persons. After that decision, Mr. Teller has filed a petition for rehearing en banc, and it is still pending. If this petition will be successful, which means that we will be seeing at least one more decision from the United States. The German Patent and Trademark Office, the decision was actually, the scenario was actually the same. Patent and Trademark Office also rejected these applications because designation of inventor does not comply with the Patent Act, which requires a person inventor, and Teller appealed this decision again. Federal Patent Court also dismissed the appeal. They said computer-generated inventions are patentable, yes, but there is a need to indicate a human being as an inventor. This decision is now under appeal to Supreme Court. The New Zealand Patent Office also decided that the application for the grant of a patent void because this application does not indicate any natural person as an inventor. Also, Commissioner decided that there is no valid transfer of rights because machines has no rights that could be subject to any transfer. That's why they rejected these patent applications again. And Mr. Teller has appeal this decision. It is subject to appeal to High Court. The Australian Patent Office and the decision of the Federal Court of Australia was really important and was really significant. Why? Because firstly, the Australian Patent Office, like any other patent office, rejected the patent application. They said the application has lapsed because artificial intelligence system cannot be an inventor since it's impossible to identify a person who can be granted a patent. After Mr. Teller has appealed that decision, in 2021, we have seen a very significant decision from Federal Court of Australia. They said non-human and artificial intelligence can be regarded as an inventor because, firstly, there is no specific provisions that preclude the possibility of inventorship of artificial intelligence. Secondly, they said functioning of artificial intelligence is really same with the human brain. And thirdly, they said AI and AI-generated inventions, AI-devised inventions are really important for promoting innovation. That's why we have to protect them. Furthermore, they said relying on a dictionary definition of an inventor is not a very valid or reliable source because definitions are subject to change historically. So if we have an AI inventorship, if we have seen an AI inventorship, that it is subject to change. Actually, this definition is subject to change. And finally, they relied on principle of accession, and they said the owner of a property will also be the owner of outputs that generated by that property. As a result, they said, yes, artificial intelligence can be an inventor, but they cannot apply for a patent or they cannot be grantee of that patent. It was a very significant decision. It was a very huge success for Devos team because it was the first time that a court has said, yes, there is a possibility of artificial intelligence as an inventor. However, it didn't last very long because Commissioner of Patents has appealed that decision and Federal Court of Australia has changed their opinion and they said only a natural person can be an inventor for the purpose of the Patents Act and regulations. It was a very huge backstep for Devos, and Mr. Teller has said, has applied for a special leave to appeal that decision. But just 10 days ago, we heard that Australian High Court declined permission to appeal. Which means that Australia is now only jurisdiction that we have a final non-appealable denial of the patent application. Not but not least, we heard a South Africa's decision. It is very important for Devos because it is the first and only country which accepts Devos as an inventor. And the patent application has accepted by South Africa's Companies and Intellectual Property Commission in June 2021. However, it is not a very huge success or progress for Devos because South Africa does not have any substantial examination of patent application. As long as the paperwork done correctly, everyone or everything can have a patent protection in the South Africa. But at least I have one country that accepts the possibility of Devos decision, Devos as an inventor. To sum up, what is the current situation right now? As I said, 18 different jurisdictions were subject to this application. And in 16 of them, the process still continues. As I said, Australia is the only country that we have a rejection in a non-appealable denial of the patent application. And South Africa is the only country that a patent has been granted so far. Finally, I just want to mention about what is the importance of Devos cases, just a few words. It was a test case, actually, because Stephen Teller knew that if he said just, okay, I'm the inventor of this invention, he could easily get a patent protection for these inventions. However, he wanted to test the system. He wanted to see how the system will react for these kind of applications. And for me, it was a very successful initiative because it raised lots of attention, especially in the public and governmental domain, because we have seen lots of public consultations, guidances, or questionnaire from lots of countries or from the organization like WIPO. And also it questioned a little bit the human-based patent law. If we accept AI inventorship, what would happen in the patent law domain? For example, do we need to change the requirements for patent protection? Or, for example, do we need to change our perspective to decide inventive step, for example? Do we need to change person skilled in the art, this fictional person, because it is a person and it is just an average person in their field? So should we expect that this average person would be able to understand the AI inventions generated by AI inventions? Furthermore, it questioned the enabling disclosure, whether or not we can enable a disclosure for AI invented, AI generated inventions. When we think about the black box mechanism of AI, or what will be the scope of this disclosure? For example, do we also need to share the data that we have used to train that AI, or do we also need to share codes or algorithm of AI? So lots of things has started to question with that case. And finally, we can also question term of protection. For example, 20 years is fair, whether or not 20 years is fair for artificial intelligence generated inventions. These are my observations so far related to Davos cases and importance of Davos cases. And thank you for listening.
Thank you, Mrs. Fatma. Thank you very much for addressing this interesting topic. At the end of the session, we will have questions. If you have any question, you can type through a chat box. Now I will now return the session over to Dr. Meltem Karatepe-Kaya from Istanbul Medeniyet University. She will be speaking to us on sustainability and digitalization, challenges and opportunities for corporate governance. The floor yours, madam. You have 15.
Thank you very much, Dr. Serkan. Hello, everybody. It's my great pleasure to welcome you to my presentation about sustainability and digitalization and its impact on company law according to the future of corporate governance. First of all, I would like to thank everyone who contributed to this wonderful conference, and I would like to introduce myself briefly. As Dr. Serkan said, I am Dr. Meltem Karatepe-Kaya. I am assistant professor in commercial law department at Istanbul Medeniyet University. So what is in my agenda today? I mean, what do I want to talk about today with you? Today, first of all, I will give information about the digitalization in corporate law and its impact on corporate governance. And afterwards, I will give information about opportunities for corporate governance from AI and blockchain technologies, such as AI director and blockchain-based general assembly or board meetings or trade registries. So, as you all know, sustainability and digitalization are the most important topics of discussion all over the world today. And these two significant factors are also at the forefront of the elements influencing corporate management and the future, I think. In reality, the use of blockchain technology, artificial intelligence, AI, and machine learning in many professional stations in recent years has shown that the interaction of digitalization with corporate governance and sustainability cannot be denied. And in companies, as in everything else, digital transformation entails establishing a new structure by abandoning the traditional. So the adoption of digital transformation is expected to strengthen, simplify, and improve the relationship of companies with internal and external stakeholders, and those will increase the company's efficiency. Along with digitalization, the achieving of corporation sustainability aims is one of the other top priorities of the corporate governance nowadays. So authorities, the countries, the systems, they are looking for the some regulations, guidelines for businesses to adopt an environmentally and human rights conscious management strategy. Actually, we were talking about these issues on ESG talks in many years, but in recent years, for example, in the EU recently adopted corporate sustainability reporting directive, which brings additional requirements for large companies, and the intersection between digitalization and sustainability in corporate management, as well as the future of corporate governance, will be addressed in this talk in the lights of all of these developments. So, as a beginning, actually, I have a long paper, but I would like to summarize my findings, and I would like to start with impact of AI, impact of new technologies, digitalization on the companies. First of all, I would like to start with AI, and then I would like to keep it very short because I know that it is a very popular topic and it has been spoken so much in recent years. So then I will forward to blockchain technology and its impact on corporate governance. First, if we start with AI. As you all know that using AI in the corporate decision-making process gives rise to several legal discussions in many years. So it has some aspects. For example, we discussed appointment AI as a director in the companies, as a board member in the companies. And then we said that we thought that, okay, it's an option, but AI doesn't have legal responsibility, legal personality, a capacity which is recognized by the legal system. So if AI makes a failure, and maybe if it's damage to the companies, who will be responsible? So, because of these discussions, legal personality issues, we moved another issue and we discussed about the assistance AI. So, because of the appointment of AI as board member has not yet been fully vitalized, but leaving decision making to AI or obtaining help from AI in decision making process is already a very common business practice. We move another topic. How can we get benefit from the AI in our companies? Actually, we are using AI in our companies and we are getting benefit from these systems. We are getting benefit from the, for example, for merger and acquisitions, we are getting benefit from some autonomous systems. It is not unusual. I don't want to mention so much. I don't want to go further of discussions about AI director, because even if we say that because of AI doesn't have legal capacity, legal personality, there are some discussions, ongoing discussions. The European Union, they are focusing on these issues so much and they are preparing for new regulations to make AI responsible. I don't know how can it be possible, because it is really debatable, because even if you put an AI to the prison, it doesn't make sense, and you have to find some responsible factors to get your damages for your companies, for example. So I don't want to go this subject further as a corporate lawyer scholar, but I can say that even if we say that it's not possible legally to appointment of an AI to the companies as a director, now we have some examples. For example, in Hong Kong, company, the venture company, appointed an AI director, Vital, as you all know, I think. And then a Nordic company, Aliciati, was appointed as a director. So those examples can be seen, but I can say that even if some countries are not ready for non-human directors, legal entity directors, so I think we need some time to comply our companies to AI director. What about the other benefits of AI to the companies? As you all know that we have 4 core principles of corporate governance: transparency, accountability, monitoring, equal rights for shareholders. And we have some discussions on corporate governance. For example, one of the most popular discussion is agency conflict between the managers and shareholders in dispersed ownership companies. In concentrated ownership companies, this conflict is between shareholders, between majority shareholders and minority shareholders. So we can see the aspects of the agency conflict in many corporate governance failures. For example, in Enron, we can see the conflict between managers and the shareholders, and in Parmalat case in Italy, we can see another aspects of this agency conflict between minority shareholders and majority shareholders. So I think AI has a significant potential for the company's decision-making progress, and it can operate in a sector that can be handled remotely rather by people, therefore avoiding losses and gaining expert guidance. And we can also get benefit from AI in some other areas, as stated by Armour and Edelmüller. We can use AI in other companies, in other corporate functions, as information and communication management, investor profiling, product development, monitoring, profitability, risk, compliance, decision-making regarding corporate strategies, investment, and manufacturing, control, pricing, sales, marketing. So at the end of the day, I think at least we can solve the agency conflict problem between the different factors. And because of the AI help us to provide more transparency and monitoring, we can have a better level of corporate governance in our companies. But we have to be careful about those technologies, as Luca and Ziche claim that if AI were take the role of human populated boards, the options available to shareholders will be no better than they are today. And maybe we can solve our problems based on the human populated boards, but we might have some other problems. And also, I have to say that we have to keep our mind to the new technologies doesn't promise us a world, doesn't promise us Alicia's Wonderland, and those new technologies has their own drawbacks. For example, for the AI, we have to be careful about its discrimination and bias problem, and if we forget those drawbacks, those disadvantages of AI, maybe the other managers can live their own ideas, their own thoughts, and can follow in all of their decisions to the AI. So we have to remember that AI also has a human-based system, which based on the designers' ideas, designers' thoughts, designers' interests. So the claim that the AI director will add a professional perspective to the company's management and streamline operations is debatable. It might get bring benefit for the company, and maybe it will cause a reduction in agency costs, monitoring costs, but we have to be careful about some issues such as discrimination and bias problem of AI. We have to create trustworthy AI systems as recommended by European Union directive regulations. I don't want to, as I said before, I don't want to go so much deeply about the AI systems and its impact on companies. I would like to move another important issue, which is the use of blockchain technologies in our companies and in the companies, general companies.
Doctor, you have 5 minutes to conclude, please.
Oh, thank you very much. So today, the most of the countries got benefit. Most of the countries, company law systems actually got benefit from the digitalization for the corporations, particularly non-physical. I mean, electronic or virtual meetings are seen in many countries. Even if I talk about the new technologies, especially digitalization based on digitalization is exists in our life in many years, and I think Turkey is the maybe second, maybe first country which has which provides the electronic general meetings to the shareholders. So now we have some other technologies. For example, when we look at advantages of non-physical electronic or virtual meetings, the companies and shareholders' rights and eventually corporate governance, which has been implemented for years, corporate governance has been developed, but today I can say that we have new possibilities. We have some new technologies. So we have a possibility to develop a general assembly or a board of directors meetings with blockchain technology, including smart contracts and distributed ledger technology, DLT technology. So we can use these technologies by preparation of annual general meetings or other meetings, and in this case time limitation will be removed and we will have more time for the shareholders for speaking speak of their issues, talk about their issues. So there will be no restriction of majority of the shareholders, and small shareholders will have more incentives to engage in decision making, and fast decisions may be made because of the very different notice periods of annual general meetings in blockchain technology. So with this technology, we can improve our corporate governance in systems, in companies. What can we do with this technology? I would like to summarize. I would like to be really quick because I don't have so much time. I think I have limited time. We can use blockchain systems. For example, we can use this system actually from the foundation of the company to termination of the company. For example, this system might use to register with trade registry. It looks like a good idea to keep national records on blockchain because it can be used as proof and is a reliable way to transfer information. But in this case, we have a problem. I have to point out that abandoning the central control mechanism does not seem possible in short term for trade registration systems, because for trade registration of a company, we need more centralized systems right now. So it doesn't seem possible in short term, but there's another possible usage of blockchain on company law, which is keeping share ledgers, I mean share books on the system. I must say here that since the principle of trust in the registry is not in question in terms of the share book, as the land registry and security measures regarding the accuracy of the information in the records don't need to be same level, it looks more possible to keep the share ledgers on blockchain than the trade registration in short feature, because the records in share ledgers are explanatory and constitute a refusable presumption against share ownership. So therefore, it has no effect on the acquisition of property. So it looks
you have
more
1 minute,
possible
please,
for the companies. And another usage of blockchain might consider it for the creation of financial records, and we can use this system, as I said before, for general assembly meetings. And I think that it will improve the shareholder engagement and participation of shareholders to the management of the company. I wish to explain more to
with
this
few
issue.
words, please complete your presentation, Dr.
Thank you, Serkan. Dr. Serkan. I would like to explain more to these issues, but because of time limitation, I can't. But at the end of the day, I can say that even if we say it has lots of advantages, it has some disadvantages, especially when we look at the aspect of sustainability. We can have a link between the sustainability and digitalization. As I said before, European Union has a new directive, corporate sustainability due diligence directive, to make corporate managers more responsible because of the environmental and human right infringements. But still, there are some problems regarding these issues. Still, we are struggling. The countries will struggle to make managers more responsible because of this infringement, especially if it is happening in another country, in another land. So maybe digitalization may help us to solve those problems. But I wish I can share my ideas and other presentation with you regarding this topic. But finally, I can say that those technologies.
Few minutes.
Thank you very much.
Few sentences to conclude, please.
Okay, I have to conclude that those technologies may help to improve corporate governance, may help us to reach a good level of corporate governance, but we have to be careful about their drawbacks as well. For example, we have to be careful about data protection issue in blockchain systems, because it keeps everything in its inside. So if we have careful regulations, then at the end of the day, we can get benefit from those systems and we can improve our corporate governance very well. Thank you very much for your attention, and sorry for being late.
Thank you. Thank you, Doctor, for your presentation. I'm really sorry. Just I give more time to Dr. Martin. So now I will turn the session over to Mr. Furkan Bulut to begin. He's also a PhD candidate at Swansea University in the UK. His presentation is about the assessment of the EU product liability regime in the context of artificial intelligence and related emerging technologies. You have 20 minutes, Mr. Furkan.
Thank you, Dr. Kaya. First thing first, let me set my time. I'm sorry for this. All right. So first of all, I'm sending my regards from the UK, from Wales. It's an honor for me to be part of this reputable symposium. Thank you to the IT and Technology Law Association, Istanbul Medeniyet University, and all the team working behind for this tremendous event. Today, my presentation will be as to how the European Union approaches the product liability issues regarding AI and related concepts by analyzing the current regime. The issues have been quite topical, as we all know, and have had a great importance in the last 4 or 5 years, particularly. Now they took a step forward with the new proposal to adopt another product liability directive, which is going to be repealing the existing one, if it goes through, of course. So I am going to start by providing with a summary on what's going on lately, and then for a clear and better understanding, I'm going to provide some short explanations on the systems of AI and some other subfields. I'm pretty sure AI has already been defined 1,000 times, and since this is the last session, and also Dr. Meltem Kaya mentioned. So I'm going to try to keep them very peculiar to the product liability issues. Then a general review of the product liability regime, the legal instruments to compensate the damages faced by the injured parties. And then the main part of my presentation, directive, the elements of the current strict liability regime, of course, in accordance with the findings from the definitions of emerging technologies. Then new proposal, and finish with my final remarks. So here is the list of some relevant reports, studies, workings conducted and published by the European Union. As you can see, we have two proposals on non-contractual liability for AI and a new directive for product liability. In 2017, the European Parliament called for a uniform regime on robotics, and liability was advised to be channeled to the person who is able to minimize risks and deal with the negative impacts. So as you can see here, the fact of the control of the AI-driven system is considered here. It is also suggested that it might move forward to strict liability, given that the negligence of the operators, the users, the owners, keepers, and their roles will be kind of faded away in conjunction with the algorithmic decision-making systems. And as core the characteristics of AI convey the dominance to the product itself, cutting down the dependency on human operation and taking into account the balance for which to set risks with fair apportionment between the parties. The scope of the product liability has been at the forefront of the areas in the agenda of the European Union. However, what kinds of core characteristics we are talking about here? This is quite important because they trigger every single detail of the existing regime. So there are, of course, many more, but here's the list of some important concepts. We're talking about big data, which refers to very large amounts of data sets, of which the complexity kind of poses an obstacle to conventional type of data processing softwares. Cloud computing, blockchain technology. So through the environment they result in, data becomes private, immutable. Sometimes it is sovereign itself without being controlled by a single entity. These can be considered as the initiatives that enable to collect data from everywhere today, rather than local storage in the electronic device, via machines, sensors, smartphones, web, and eventually any platform catering the digital format might be coming from external vendors as well. There's also the concept of IoT, Internet of Things, that takes up too much spot within this smart society, that enables physical and virtual devices to connect to internet, to share data, creating a global infrastructure and interconnection among numerous areas of everyday. We have concept of machine learning that takes the subject a step further, setting off a significant domain of AI research. Broadly speaking, transforms experience to expertise or knowledge through the mechanism of which the input comprising training data is converted into the output that mostly gives way to another computer program. This is part of the not programming with the predetermined responses to a situation, but rather creating learning algorithms based upon its own responses to that situation by means of training data. Here, learning process is divided into supervised, unsupervised. Well, unsupervised machine learning added labels help the learner to be supervised by the teaching environment to estimate the missing information unavailable in the test example. Whereas there's no such setup in the latter case. So of course we are more types, but to sum up, we can say like it helps collision avoidance, possible robot operations in complex environments. They pave the way for this kind of human operations and all operations beyond the human capacity. We have deep learning as a branch of machine learning, with which to amplify this self-learning mechanism, thereby accommodating with the highly complex functions. They are kind of considered as engineered systems originated from biological brain, and the corresponding term reflecting this idea was called artificial neural networks. And then the final one, the last one, which is the main topic of this presentation, the term artificial intelligence, the term reflects a concept that encompasses learning algorithms, a vast set of diverse approaches that benefit from data science and techniques, all the technologies that I told you, that promise human cognition. That's the key word. And in the most general terms, this is the research on agents that perceive the environment and execute some tasks by taking actions. From the speech recognition to future illness estimation, helping doctors out, the autonomous vehicles, all the sectors have been growing through this supersedence, as we all know. So what are the key outcomes for product liability? So we are talking about decentralized and dispersed data, non-embedded and non-embedded sources and interconnection. So these are basically data whose collection process has undergone a change through the systems I told you, like cloud computing, IoT might be obtained from any platform for the product. At a later stage, after it's releasing, products releasing to the market as well, that also means that it may perform together with another product sold by another manufacturer, run by another, different owner. So, and also continuing progress, this creates uncertainty, legal uncertainty, as well as difficulty to set threshold measures for AI-driven devices. The most important one, last but not least, well, this is, of course, not the last one, but one of the most important ones, the self-learning mechanism. The human involvement is being eliminated, and the products are independently learning and acting without a human interrupting. Of course, this can be considered as advanced level, but it's going to be reality at some point. So let's start the legal aspects. Well, basically, what are the sources of product liability? There are negatives and positive sides of each, but the first one is contractual liability. Well, the purchaser may certainly bring an action against the sellers. The positive side here, pure economic loss can be covered. The negative side, there's privative of contract. This is an obstacle for third parties. Contractual action is certainly not the only remedy through which the damage or loss may be compensated. The manufacturer or other associated person may surely be held liable for a claim based on thought of negligence. The third parties might also seek compensation here. The positive side is here, but there's no limitation as set out in strict liability regime directive. But in the end, it's a fault-based liability, so the claimant needs to prove fault. And the last one, the directive, which is our topic, it is basically provided with the strict liability regime. No need to prove fault, but there are many limitations. So let's start the elements of the directive. Basically, the notion of product is defined as all movables with the definition of even if incorporated into another movable or into another immovable. So based on the portrait given here, one might approach the issue from the standpoint of which the embedded software counts included in the definition. In that sense, software could be identified as product, but insofar as it is incorporated into a physical carrier. Well, what about the information contained in the software or non-embedded pure software? Are they going to be qualifying a product? That's a huge question mark. Services were left out of the embed. So whether or not service renders a service, software renders a service, is also arguable in the meaning of product covered by the directive. So considering the fact that producer is not liable for the defects occurred after putting the product into circulation, the issue becomes even more problematic for data provided by an external vendor, as I said before, at the later stage, or through interconnection. You know, the main outcomes from the use of AI. You know, the interconnection with another product. So non-embedded software or pure data obtained by an external body, signal provider, IoT systems, cloud computing, they trigger uncertainty here. Upgrades, updates, they are deemed the essential of the AI-driven products, but same questions here, same question for these elements are valid. For outputs revealed by the product itself through that self-learning mechanism, the discussion gets even more complicated. Producer, notion of producer. Well, the liable persons are enumerated by the Article 3 of the directive. Well, manufacturer of a finished product, a component part, the producer of any raw material. There are lots of people who can go, but even like supplier is also liable in case where the producer or importer cannot be identified, unless she informs the injured person, you know, within a reasonable time. The range seems quite adequate here, even when AI-driven products are taken into account. But
you have 5 minutes.
All right, okay. The difficulty arises from the fact that producer of intangible components might not potentially be identified due to the mentioned features, or the claimant may not have the you know, anyone to direct his claim within the European Union zone. When it comes to the notion of defects, the definition here, safety which a person is entitled to expect. So we are talking about safety here, but what kind of safety? Safety which the public at large is entitled to expect. So it may be stated as a reasonable expectation, but what kind of reasonable expectation? What is that? Especially when it comes to AI-driven products. There are currently like tests applied, the consumer expectation test, risk utility test. But given the complexity of AI, neither the concept of consumer expectation test nor risk utility test will be, you know, as readily applicable as currently they are. Damage. So we have death, personal injuries, any item of property other than the defective product itself under Article 8. But the important point here is that the product shouldn't be used for business purposes, only consumer purposes. The same questions need to be answered here. Software, data installed, you know, subsequently. They are not covered under the current, you know, applicable regime. Economic harm is not covered. Moral harm is not covered. Causal link. So there must be causal relationship between damage and the defect, and the burden of proof lies with the injured person who suffered that damage. As you can see, this is kind of changed shape of fault-based liability. It's not pure strict liability. Basically, again, considering the features of AI and other related emerging texts, the injured persons know the actual access to enough technical information, you know, needed to show how the product is defective or causal link. Especially burden of proof for injured person is, the question is it appropriate when the position of the producer is considered? It's a question mark again, because the actual person who has the access to enough technical information here is producer. There are some defenses. As I said before, the manufacturer is not liable for the defects that didn't exist before putting into circulation. Also, in case of the objective of state of scientific and technical knowledge at the time product was placed on the market couldn't be discovered, the manufacturer is not liable again here. So new proposal. With the new proposal, the scope of the definition product is extended. Basically, all the intangibles are included unless they are pure information, for instance, like source code of the software or open source software for free. Still, services are out of the scope. However, related services are included as long as they are within the control of the manufacturers. The control of the manufacturer is important here. The term control of the manufacturer. If she authorized third parties, it is going to be considered as the control. The definition of damage includes medically recognized harm to psychological health, in addition to death, physical injury, and property damage. The definition also includes here any loss, that's the important part, any loss of corruption of data, but that is not, again, exclusively used for the professional purposes. Again, professional property is still excluded from the scope, but if there is any mixed use property, it will fall within the proposed directive. But again, as long as it is not used exclusively for the business purposes. The defect, same definition, safety, publication law is entitled to expect. But here, it is kind of like extended version. We have intended purpose, the group of the users, the intention of the group of the users, as followed by the Court of Justice, European Court of Justice. So it is kind of more subjective now rather than objective. And also the important fact here is that the upgrades are included as long as, again, they are within the control of the manufacturer. But learning after the deployment is included here. So that means self-learning, which is kind of contradicting, considering the directive takes the fact that directive takes into account the control of the manufacturer for all the elements. But when it comes to self-learning mechanism, it's included, which is self-learning mechanism can be an advanced level. Manufacturer cannot control self-learning mechanism, as I said before. Manufacturer will be liable also for updates and upgrades if they are necessary to maintain the safety. But what is necessary? So it's also a question mark, which creates a broad gray zone for the courts. The liable persons.
Could you kindly please conclude your presentation within a minute, please?
Almost done. All right. Liable persons are defined now. Economic operators, same persons, but also include authorized representative, fulfillment service providers, and online platforms here. The causal link, it remains the same, but we now have presumption of defect and causal link under some circumstances. We have disclosure obligation for the defendants, disclosure of the evidence under some circumstances if the technical knowledge is huge to be proven by the claimant. So since I don't have that many times, so much time, I can okay. On the next slide. So defenses, still we have development risk, for instance. It's kept, but as long as the defect arising from, for instance, modifications like upgrading, update, is considered as beyond her control or not necessary. Same question here. So great, so much broad gray zone for the courts. What is necessary here? I guess that's it. I'm sorry for overrunning the time. Thank you so much for your patience. Thank you so much.
Thank you, Mr. Furkan, for your informative presentation. So we can take questions if you have through chat box. No questions?
There is one.
Well, I can't see that. Okay. There's a question to Mr. Bulut. What's the position of the UK regarding product liability issues and emerging technologies, and how will this directive affect the UK?
Okay, let me note it down for a second. All right. So, of course, the new directive will not be legally binding for the UK due to the Brexit. But for instance, the previous decisions of the Court of Justice are still applicable here, unless we have another decision repealing this application. But in the end, the traders in the UK will be affected by this regime, of course, since the EU is one of the biggest trading partners of the UK, and they wouldn't like to deal with two different regimes, very broad regimes, strict liability regimes, and also. In case of the situation where they don't comply with the concept of the defect under this new directive, it can move the burden of proof from the claimant to the defendant. That's another issue, not anticipated by the potential traders. What is the position? What is the position of the UK? Well, they have more wait and see approach. So we have some reports published by product safety standards bodies of the UK. But they kind of want to solve this issue more sectoral based, let's say, and they don't want to confront and block the innovation. So we will see what is going to be the position of the UK. We will wait and see.
Thank you, Mr. Furkan. I think we don't have any other question. So today, as I said, today is the final day of the conference and the final session. So now we have come to end of this conference. I would like to express my warmest thanks to organizers. It has been truly a great couple of days. Please join me in thanking all who contribute to making this conference great. On behalf of organizing committee, IT Technology Law Association, I wish to extend my sincere thanks to our amazing volunteers, our wonderful speakers, and our sponsors, head of the Law School of Istanbul Medeniyet University, Istanbul Medeniyet University's members, students. Without them, this conference wouldn't have been possible. So hoping to see you all again in the next event. So I'm closing this conference. Thank you so much for your contribution.
Thank you.
Thank you.
Thank you.
Thank you.